Uh, Good afternoon, Justice Zondi.
Good afternoon, Chief Justice, and good afternoon to Commissioner.
How are you this afternoon?
I'm okay here at circumstances CJA. And how are you?
I won't ask what circumstances.
Yeah.
Because you might say you want to remain silent. Thank you very much for accepting the President's nomination and for availing yourself and for coming to this interview.
Thank you.
You were interviewed by this body for the position of chairperson of the Electoral Court not so long ago. So, although I was not in that interview, I think I am aware of the proceedings, and I have no doubt that your credentials are still fresh in the minds of some of the commissioners. We are going to ask you questions to establish whether you meet the selection criteria that we have set for this body. And after I've asked you questions, I will allow the president of the SCA to ask you questions, and thereafter the minister and commissioners. So I will ask you a few questions, and then we'll hand over to the president of the SCA. We've got a lot of material about you that you have supplied to us and other documents, and therefore we are not going to try and cover everything, but everybody is deemed to have read the information. We'll just focus on certain aspects only. In terms of academic qualifications, I see that you hold a B.Juris degree, LLB, and LLM.
That is correct, CJ.
Yes, your B.Juris you got from the University of Fort Hare, your LLB from the University of Natal, and your LLM you got from Georgetown University. Is that correct?
That is correct, CJ.
Yes, and as I understand it, you were on a Fulbright scholarship. Is that correct?
That is correct.
Yes, and your LLM was
On labor.
on labor law.
Yes.
Yes, yes. And I guess that kind of prepared you for your later role in the labor appeal court.
Well, I would think so.
Yeah. Why do you seem to doubt?
Well, yeah. Yeah, it did to a certain extent.
Yes.
Yeah.
But when you were in practice, private practice, did you do a lot of labor work as well?
That is correct, yeah.
Okay. And you practiced as an attorney for many years, and then you got appointed as a judge at the Western Cape Division of the High Court. Is that right?
It is correct, 2007.
Yes. And how many years were you in that division before you were appointed to the Supreme Court of Appeal?
2007 up until, 2013, I was at the SCA for 3 terms. And then 2014, I went back for 1 term, and then I was appointed. Second term, I was at the SCA. 2013, second term, I was at the SCA. 2014.
So that means you were how many years at the Cape High Court? About 6, 7?
Years, about 6, 7, yeah. About 7 years.
Yeah. So you have just completed, what, 10 years at the SCA?
Which is that, yes, it's 10 years to be exact.
Yes. And last year you were appointed as chairperson of the Electoral Court.
That was 2022.
Was it 2022?
Yes.
So you have been chairperson of the Electoral Court for Was it October 2022?
2022, and my letter, the certificate of appointment, it says as from the 1st of November 2022.
2022.
Yes.
Okay, so you're about 1.5 years
Yes.
in the job.
Yeah.
Okay. You have been nominated for the position of Deputy President of the SCA. And I know that with regard to some of the previous deputy presidents of the SCA, they were running the court most of the time. I don't know if that has changed. I think during the time of Judge Harams and during the time of Judge Mtiane, they were doing quite a lot of work in running the court themselves. Is that still the position?
Yes, it's still a position. Yes.
So if you are appointed, you will play that role.
I beg your pardon?
You will play, that is a role you will play, same as
Yes.
Justin Tiane.
Yes, Justin Tiane was the chairperson of the Electoral Court.
Yeah.
And he was the deputy president of that court because the chairperson of that court, of the Electoral Court, must come from the SCA.
Yes. Yeah, but what I'm saying is, as far as the SCA is concerned, if you are appointed as deputy president, the role you will play is the same as the role that Justin Tiane played in relation to the SCA.
That is correct, yeah.
It will just happen that you are also chairperson of the Electoral Court, therefore you'll be playing the same roles that he played, because he was also chairperson of the Electoral Court.
That is correct. In fact, the Electoral Court is sort of located in my chambers because we share the same building and the same facilities with the SCA.
Yeah.
So everything happens in my chambers.
Yeah.
And the secretary of that court is my registrar. So,
Yeah.
so
Okay.
it's just the extension of my chambers.
Yeah. Okay. All right. I noted that I think the GCB mentioned something along the lines that they thought that you had not written as many reported judgments as they would have expected, given how long you have been on the bench. Do you want to say something about that?
I asked the researcher to check for me, but unfortunately, there's no tool to check. But I think that, I've been at the Western Cape, I don't know how many judgments I wrote there. Labour Appeal Court. I've never counted. So, and unfortunately, the researcher said, well, it's difficult because, well, what he tried the Lexis to search for the judgment. But now he said, well, the judgment that appears, the judgment in which I also said. So those judgments that appear in the Lexis are not necessarily my own judgment. So then it became a problem to do the exercise. But I'm not sure on what basis they are saying that I've written fewer I've written fewer judgments than I expected. I don't know how many numbers they have, or if maybe I'd been given sufficient time, I would have tried some other tools to look for that information.
Well, if you are appointed as Deputy President of the SCA, you will work with the President of the SCA to address whatever challenges the SCA faces. You would like to share with the Commission your knowledge of challenges that the SCA is facing?
Sure. As it is now, I'm currently the acting DP of the SCA from the 6th of May. What I've picked up, number one, it's researchers. We have got inadequate number of researchers. That's the first one. Number two, we have got inadequate number of registrars. We've got 2 registrars, and that court is big. And some courts in the country have got more than 5 registrars. So yeah, it's a challenge for the registrars. If we can just have the number of registrars increase, that will help us. If we could have the number of researchers, as it is now, we are having 3 researchers serving 26 judges, plus the judges of the electoral court, because we share the facilities with the SCA. So you could imagine what kind of a challenge they are facing. So it becomes a problem for us to deliver, to do our work in sort of in real time because of these challenges. And another thing, we've been busy with the president compiling the role for the next term. When I look at the role, there are so many matters that were withdrawn from the last term. And now, all of a sudden, these people, they are applying for matters to be enrolled. And so they are creating a problem for us in terms of allocation. So, but that's a function of the rules of the SCAs, because they do allow the registrar to take into account the availability of counsel when they do allocation. So what we need to do, I think that rule it must be amended or must be done away with, so that it will make things easy for us to do allocation. Because now you find that the matters that were crowded out last time that could not be allocated last term are now going to be crowded out because of those matters that were postponed or removed from the roll for some other reason. So if we can have that taken care of, it will assist us in terms of managing the role of the SCA. Another thing that I think that I should mention is a security issue. It's we have had some nasty incidents either in court or around the precinct of the court where our colleagues were robbed of their phones. So there's a problem with security. So, yeah.
So it's the researchers,
the registrar,
the registrar, the security. What was the other one? The fourth one? Something about management of the role.
Well, that's now. It's about the rule of the SCA, which provides that in allocating the matters, that is Rule 13 or 16A, the registrar must take into account the availability of counsel. Counsel will say, I'm not available, I'm available on XYZ date. And so now we are sitting with the role. You need to allocate matters, about 60-something matters. So now, if you've got a situation where counsel will say, I'm not available on XYZ date, and this counsel said, I'm not available on XYZ date, what do you do? So I think that rule must be either amended or something needs to be done to it, because it's making our job difficult as it is now. The other thing that is a problem, obviously, is the resources. I'm talking about the law reports. The law reports.
Oh, okay.
Yes, the law reports and the statute book. We are no longer receiving the last time we received the statute book was 2019. So the bound statute book, you can only find them in the library, but not in our chambers. The same applies to the law reports. The last time we received the bound law report it's 2019 or 2019. So it's either available to them or electronically, and LexisNexis can be accessed at any time electronically. But JUTA, it's a program. You cannot access a law report which is published by JUTA if you are working away from the SCA, because once you are away from the system, it's going to deny you access. So you need to be using the SCA network for you to be able to access the JUTA law report or electronic version.
Okay. Okay. Thank you very much, President of the SA.
Thank you very much, Chief Justice. Good afternoon, Justice Zondi.
Good afternoon, President Molimet.
Yes, as you correctly pointed out, you are now the acting Deputy President.
That is correct.
From the 6th of May.
Yes.
Yes, so the correct way to address you is acting Deputy President or ADP.
Well, if you say so, I will say no.
Yes, thank you very much. Justice Zondi, you have alluded to some of the challenges that are facing the Supreme Court of Appeal, and you alluded to the issue of the inadequate number of researchers, which is something that was also touched on during the interview of the DCJ. But something that perhaps I would like to raise here and get your views or your comments on is the tenure of researchers, because from my point of view, we are having or experiencing a very high turnover of law researchers. The reason being they are all appointed on a contract, and naturally, when the third year of when they start the third year of the contract, they have to start looking for jobs elsewhere. And sometimes when they get appointed before the end of the term, they leave before the end of the term, which is one of the reasons why we have such a high turnover. Now, considering the status of the court as the penultimate court, appellate court, I think you'd agree that our court can ill afford to, at any stage, have an inadequate number of researchers. Do you agree?
I agree with you entirely. And the example that you have given of a researcher who, because of the nature of the appointment on a short-term contract of 36 months. So others, your life, once you leave school, you need something that is going to give you some degree of permanency. You have got a family, you have got maybe the loans to pay. So you get this contract for 36 months. And in the meantime, within a year, you try to find something so that by the end of that 36 months period, you know where you'll be. So in some situation, it has occurred twice where the researcher had to leave before the expiry of the 36 months because he got something better, either at a university to do research on a permanent basis. So really, it does become a problem. It creates a challenge for us. My registrar that I was using previously, he also had a similar kind of situation where he was employed on a sort of short-term 36-month contract. But because there was somewhere else where they could offer him some permanent employment, he had to leave because he could not wait for that 36 months to end and not knowing what will happen. I mean, once you start working, you create some commitments, and those commitments need to be financed. So you can't have a situation where your life starts at somewhere and then 36 months, it ends and then back to zero. No. So yeah, it does create a problem for us, and I think that is something that must be looked at.
Yes, thank you. Do you think that the problem could perhaps be alleviated by using a hybrid kind of system in terms of which some are on a contract, but others are, on the staff, permanent staff establishment. In other words, permanently appointed in that capacity.
Yes. That might help because in that kind of a situation that you've sketched out, you are able to maintain and to continuity. So there'll be always somebody available to assist us, that is the judges, and there will be always somebody available to train the incoming researchers. So yeah, I think that that might be an ideal solution to the problem.
Thank you. ADP, in terms of Section 52B of the Superior Courts Act, the Deputy President of the Supreme Court of Appeal performs the functions of the President of the Supreme Court of Appeal whenever the President is absent or when there is a vacancy, which means that you have to be au fait with all the functions of the President of the Supreme Court of Appeal. You agree?
I entirely agree.
Yes. You are familiar with the management of that court in the sense that not only have you served in that court for 10 years, and you mentioned now that you actually started acting a year before 2014. You were appointed in 2014, but started acting in that court in 2013.
Yes.
Yes, so you are familiar with the workings of the court. Is that correct?
Yes, I understand the culture of the court. And for me to be able to assist the president in the performance of her duties, whatever will be allocated, the functions that will be allocated to me, I need to understand her vision. I fully embraced her vision and adopted and the vision that is based on 7 pillars, and I will assist her in the execution of that vision.
Yes, you are the chairperson of the Electoral Court. Would you say that that position has prepared you for the position that you'll be appointed in?
Well, it has.
If you are recommended?
Yes, it has because, well, as a chairperson of the Electoral Court, I attend the heads of court meeting, and that's beside the work that I do as a chairperson of the Electoral Court, and I'm also serving on Judicial Accountability Committee, which is chaired by DCJ. And as a chairperson of the Electoral Court, I mean, it doesn't have a budget. Zil, nothing. It entirely depends on the SCA. So I have to do the allocation of cases, find judges. So it involves a great deal of management.
Yes. You are currently the chairperson of the House Committee of the Supreme Court of Appeal?
That is correct. And the member of the Budget Committee as well.
Excuse me?
And the member of the Finance.
Yes, a member of the Finance Committee.
Yeah.
Yes, would you say participating in these committees and also chairing one of these committees has also, in a way, also familiarized you with the management of the court?
Yes. I mean, now as a chairperson of the Housing Committee, you are responsible for the administration of the court and security, whatever that needs to be done in court. And give a report to the president. Yeah, so I know what is happening in that court and what needs to be fixed by virtue of being the chairperson of the Housing Committee.
Yes. Ever since your nomination as the incumbent in this position, you and I have held several meetings that were intended to familiarize yourself with the role of the President of the Supreme Court of Appeal. Is that correct?
That is correct.
Would you say that you have sufficient, before that question, you have also handled a number of Section 17(2)F applications, which in terms of the Superior Courts Act are supposed to be attended to by the President of the Supreme Court?
That is correct. That's what I've.
You have also played a role in the preparation of the role for the next term.
Yes.
Now, given these meetings that we have held and your role as the chairperson of the Electoral Court, and also having participated in the meetings of the heads of court for 2 years, do you think you are ready to be appointed into this position as the Deputy President of the Supreme Court of Appeal, and also ready to step in as the President of the Supreme Court of Appeal whenever the President is not available?
I'm more than ready,
Thank you.
President Molimela.
Thank you, ADP, thank you, Chief Justice.
Thank you, Minister.
Yeah, thank you very much, CJ, and good afternoon, Acting President, Deputy President Zondi.
Good afternoon, Minister.
Will you also maybe be able to share with us how your experience at the Electoral Court in terms of the administration of the role will further help you in this role?
Yes. This year has been the most litigious year in the history of this country when it comes to electoral matters. And okay, let me start by just explaining the structure of this court. In terms of Section 18 of the Electoral Commissions Act, it consists of 5 members, 3 judges and 2 non-judges members. At this stage, we've got Professor Puko and Professor Makanya as additional members. The permanent members, we've got 2 at this stage. We've got two permanent members, which is myself and Justice Mudiba. And I rely on the acting judges. Now, as I've just indicated, that this year it's the most litigious year in the east of South Africa when it comes to election. Between the period just after the president announced the election date, there was just a flurry of litigation cases, people applying for people in new parties wanting to be registered, and some objecting. But what created the problem here was the publication by the IEC of the election timetable. That election timetable had the timelines that were fixed were too tight. And we've got a situation where I don't know how many political parties are registered now, but we had a number of political parties wanted to register for election, wanted to contest the election. And the problem it will seem the system that the IEC is using for compliance with Section 27 of the Electoral Act was a system that was too difficult for the new parties and the independent candidates to understand, because most of the complaints that we received was that we were kicked out and were unable to register or were unable to do X, Y, Z because of the system. We did not receive proper training on how to use this online registration system. So as a result of this disagreement between those who wanted to register or to load the list, the candidate list online, and the IEC, we received a number of cases. So between March up until, say, the 9th of October, which was the 9th of April, we received not less than 22 cases. Now we've got 22 cases. All these 22 cases are urgent, and they need to be dealt with in terms of the election timetable fixed, published by the IEC. We were expected to give the decision on appeal by the 9th of April. Now, we're running this court as if we're running a motion court. But unfortunately, in a motion court kind of situation, we are able to allocate one judge and say, do this role, and allocate another judge and say, do matters A to C. But unfortunately, because of the manner in which this court is structured, it's difficult for one to,
I don't want to stop you, Zondi, maybe
Yes.
at some point.
Sorry.
Yeah. I'm just saying you should conclude on the.
Oh, okay, no. So I'm saying that the allocation is a challenge because of the number of judges that we have got. If we have got sufficient judges, then it would be easier for us to manage our role. Yeah, that's basically what I wanted to say.
My second question is with regards to this judgment of the court that was delivered yesterday on the matter related to former President Zuma. And I agree with you in the court on the reasoning with regards to remission, although I saw there were a lot of divergent views. To a certain extent, I agree that it does not affect the conviction or sentence. It's an issue of execution.
Yes.
Where I'm a bit lost is how did you get it completely wrong, the interpretation of Section 47(1)(e), despite what has proven to be available authority that the ConCourt has pointed us to in their recent judgment, which they point how the rules of interpretation and how it should have been handled.
Minister, we have to be careful about judgments because on the one hand, anybody can be wrong, any judge can be wrong, and sometimes you say a judge is wrong today, but a few years' time, everybody's saying he was the one who was right. But we have got to remember the focus of what we are required to do. If your question is directed at showing that he got it so wrong that it will affect suitability for the position, then it's fine. But if you can't go that far, it becomes problematic what purpose it serves. If it can't show that he's unsuitable. In other words, if it's not a situation where you say, you can only be this wrong if you are not suitable. So I thought I must just mention that and leave it for you to reflect.
No, thank you, CJ, for that guidance. I'm just dealing with the issue of the interpretation of the Constitution, which I guess is the responsibility of the judge. It's not, as you said, that is
Okay.
it's just about the interpretation, which I believe it's a manual day-to-day.
Okay.
Yeah.
I think that CJ can handle this question. Minister, let me, it's when it comes to interpretation of the statute, there is no right or wrong approach. You look at the words of the statute and you apply the well-established method of looking at the interpretation of the statute and arrive at the conclusion. That conclusion might be right or it might be wrong. So, and remember, you are dealing with words here. You have to ascertain the intention of the legislature from the words used in the statute. So, one party might, looking at the very same statute, arrives at a different conclusion. There is no guarantee that if two people interpreting a statute will arrive at the same conclusion regarding the meaning of the statute. Because I mean, it's not a scientific approach. It's not a question of 1 + 1 = 2. So yeah, there are some cases where I was the minority when it comes to the interpretation of the statute, but some years back, that minority judgment became the majority judgment. So today you might be in the minority when it comes to interpretation, but tomorrow your reasoning might become the basis for the majority decision. So there is no clear-cut answer. There is always a room for error, Minister.
Thank you, CJ, and thank you, Acting Deputy President Zondi.
Thank you, Minister.
Thank you. Well, Justice Zondi, I was going to say, if you say there is no wrong or right answer when it comes to interpretation, some judge in the High Court whose judgment you may have overturned, where you said their interpretation was wrong, is going to say, what does this mean now? Commissioner Baba.
Thank you very much, CJ, and good afternoon, Judge.
Good afternoon, Commissioner.
Thanks, Nanda. If appointed Deputy President, and effectively you double up as a chair of the Electoral Court. I mean, you've just stated that.
Yes.
And you said that, I think it was mentioned that late Judge Tiani occupied both positions. And since then, of course, our democracy has matured and it continues to mature. And this has necessitated Parliament to amend the Constitution to provide for independence and so on and so forth. Furthermore, you lament the fact that the manner in which the court is structured and it poses challenges to the management of cases and still keeping within the strict timeframes. Now, it takes me to this question. Given your experience, is it really proper to lock these two positions in one person? If you were to be honest with us, having this experience and said what you have just said just now. Thanks.
As I've indicated, as I've indicated just earlier on, Commissioner Clara, the court is located in my chambers. So the files get sent to my chambers, I look at them, I read them, and I gave instruction to my registrar, like in terms of sending out directives. So I don't foresee any problem because it's something that I've been able to do without any problem, and I'm not sure if there will be any problem in terms of managing both courts.
Just a quick follow-up, CJ. Yes. My apologies. And given what you have just said now, what really motivates you to wish to occupy both positions, notwithstanding the fact that you were responding to the nomination of the president?
Sorry, I'm not sure if I understood you, Commissioner Klaba.
What motivates you to want to occupy these two positions? And of course, I'm saying notwithstanding the fact that you are responding to the nomination, you did not apply for it. Would you have really applied for it if it was not for the nomination from the office of the president?
Well, no, I would not have. You know. But yeah, it's maybe the president saw something in me. I'm not sure, but I think that I fully appreciate and understand the challenge that lies ahead, and I think that I will be more than capable of dealing with whatever challenges that I might face. You know, for the past, for 4 years, I was a member of Judicial Conduct Committee, which deals with complaints against the judges. So, and although there is a lot of work there, but it never interfered with my core judicial function, which is writing judgment, because that's a core judicial function of a judge, to deliver judgment, to write judgment and deliver judgment. So I'm saying that after the expiry of my term as a member of JSC, then I was appointed as a chairperson of the electoral court. So the point that I'm trying to make here is that I've been able to take extra as and when I'm required to do so, and I don't shy away from work.
Thank you so much, Nanda. Thanks, CJ.
Thank you, Commissioner. Commissioner Marmoha.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
I want to ask you about an issue that has arisen, and even yesterday it came up, of researchers. And the context within which researchers are important has been laid, and one can really understand it. And when you look at the Constitutional Court and how it operates and the assistance that judges may get, and you look at the number of researchers in the Supreme Court of Appeal. But I think we need to really understand the value of these researchers in assisting judges to be able to perform their core function. What exactly is the role of these researchers? What exactly do they do? Are they looking for legal material for judges and they are bringing those to judges? Or are they summarizing legal material for judges and they bring summaries to judges so that we can understand how they assist judges to be able to perform their duty. That is just one part of the question. The second part of the question, you made a point that currently you are able to access LexisNexis, and the JudaStat has been a little bit problematic. Obviously, there are other databases that are of assistance, and of course, perhaps maybe the Judicial doesn't have access to those, which might be a problem as well. And how about Safely? Has that been helpful? Are you able to access cases on Safely? Obviously, the older cases, it might be a problem because they might not be there, and that's where the LexisNexis of this world come into play. Is that one of the, at least in the interim, a measure that is of assistance?
Well, you do use, let me start with the last question. Safely is also a tool that one can use because it's easily accessible. But in terms of being up to date and the product that it can give you, I don't think that it's. For instance, it doesn't have like rules of court. Sorry, it doesn't have like commentary on legal literature, like Nexus and Jutas have. There is no electronic version of the civil procedure book in Safely, so it has got its own limitation. You can use it, and well, sometimes just recently we pick up that the rules that they've got of the SCA on Safely, it's an updated version. It's not. So yeah, there's always a problem in terms of using it as a search engine. Now, coming back to the first question, the researchers, I will speak within the context of the SCA. SCA, we've got what we call a style guide. In other words, we have a style guide that we used, guiding us how to prepare how the judgment should look like. And like the words that we use and punctuations, everything. We've got that style guide. The people who are best suited to understand and to deal with the style guide book are the researchers, because they are trained on how to use the style guide. So you can produce a judgment, but for the judgment to be in the SCA acceptable form, that judgment must comply with the style guide. So yeah, it's not an easy matter to produce. It's not an easy thing to produce a judgment for the SCA, because it must go through all these processes, the style guide compliance. It must comply with the style guide. That's part of the work of the researchers, to make sure that the judgment is style guide compliant. And secondly, we do use them now and then to do the research for us, to prepare memos. Like if there's a complicated issue and there's a controversial issue, to do some research on that issue and present a memo to us. I remember while I was acting in the Concord, I had two researchers in my chambers. So we're preparing memos for me. And we'll sit with them before we go to court, just preparing the pre-hearing. And after the hearing, we'll just sit with them and preparing the post-hearing note. So yeah, they do a lot, they assist a lot, because you as a judge, you don't have the luxury of time just to do some research. But obviously, you can't rely entirely upon what they've produced. You need to do your own research, but at least you've got something to work on, unlike in a situation where we have to start from scratch. So yeah, they do a lot in assisting and in making the work of the judge easier.
Thank you very much, Judge Zondi. Thank you very much, CJ.
Thank you, Commissioner Jesse.
Thank you, CJ. Good afternoon, Judge Zondi.
Good afternoon, Commissioner.
I know that you are one of the senior judges at the SCA, and as I understand, you enjoy respect from your colleagues. How that will help you in terms of leadership as you are now being nominated for the position of a deputy president of the SCA? That is your relation with the colleagues at the SCA, and what is their view about this nomination?
Yes, I must be honest with you. My colleague has been they've accepted and embraced. They are looking forward to this. To them, it appears as if it was a godsend, something. It was well received by them, and the messages of support that I've received from them since the nomination, and even when the president announced it, people clapped hands. So, which shows that they believe in my ability, and I work well with my colleagues. So they're happy.
Okay. My last question. You have referred to the 7 pillars in the plan of the president.
Yes.
In terms of that 7 plan that is there, where do you locate your role? Or how do you see yourself implementing that 7 plan?
Oh, okay.
That is my last question.
Right. Now, she has 7 priorities for that court. And I'm not sure if I can just tabulate them, but it's collegiality, allocation of cases, capacitation of research function, and court modernization, and optimizing acting appointments, and looking after the needs of the service users, that is the advocates and attorneys who are using our product, and refresher courses for the registrars and researcher courses for the judges and researchers. So one of the strategy to implement the vision is to sell that vision to the people who are going to use it, because those people are going to part and parcel of that vision. That's number one that we must take into account. And secondly, you must consistently preach that vision to them so that they will understand it. And thirdly, you must make sure that you allocate resources to pursue that vision. So these are the strategies for implementing the vision. So I will be assisting her, as I've indicated earlier on, that I fully understand her vision, and if appointed, I will be able. I'm giving my commitment to make sure that that vision is implemented.
Thank you. Commissioner Singh.
Thank you very much, Chief Justice. Good afternoon, Judge Zondi. I'm on virtual. Nandava.
Good afternoon.
To you. Nandava, yeah. Judge Zondi, you are aware of the comments by the Black Lawyers Association. I take it you've read those comments.
Yes.
Yeah. Now, I just want to start off by saying, you did not apply for this position. The president has nominated you, and under normal circumstances, you may not have applied for it if it came up.
Yes.
So, given that, normally when we consider a deputy, we consider a deputy with the view that that deputy will one day ascend to the higher office when a vacancy arises. In your case, if I look at your age, and I'm about your age as well, so I shouldn't be talking about age, you don't have much time in the service to be able to hold and fulfill this position. Do you think it would not have been better for us and for the president to have nominated a younger person from within the SCA that could be groomed by the current president to ascend to the position when the president retires or moves on elsewhere? Just your comments on that, Judge Zondi.
Well, Commissioner Singh, as a deputy president, my role will be providing a supporting role to the president. And with my experience, I mean, I've been the member of the SCA for a number of years, so I'll be able to hit the ground running immediately if appointed. Unlike a situation where you will get somebody who is, well, let me just tell you in terms of where I fit in. I am the second longest serving member of that court. So I understand the culture of that court. So that being the case, I think that it was an appropriate thing for the president to do, to nominate somebody who understands the culture of this court, who has been there, who will provide support to the president. And the president has still some years to go. So, yeah, it's unlike a situation where the president is going to retire in 3 years or 4 years or 6 years. She has some years to do before she retires. So I'll be providing her with that support. And for me to be able, for her to be able to get that support, she must get that support from a person who has been at the SCA for a longest time. I mean, I came before her at the SCA, so I've been there for a number of years. So based on my experience, I think that I'll be able to provide the necessary support to her. I think I'm not sure if I've answered your question.
Yeah. Will that be for a period of about 2.5 years or so? Until you
I'm 66
retire?
now.
Okay.
Yes, I'm 66, yeah.
Thank you, Chief Justice. Thank you, Judge.
Thank you. I'm left with one name, and I'm going to add only one more. The one I have is JP.
Thank you very much, CJ. Good afternoon, Acting DP.
Good afternoon.
Am I correct that as chair of the Electoral Court, you are a head of court? That's one. But in terms of the support capacitation around you, whilst in the SCA, it's not different to any other justice of the court.
No, it's not.
That's exactly why I'm asking you the question. You seem to be too accepting of that status quo. I mean, as incoming DP and as chairperson of the Electoral Court, you've got additional responsibilities compared to another justice of the court. Am I correct?
That is correct, yeah.
I thought as my superior, you would agitate that this status quo can be maintained.
So sorry, I'm not sure if
I'm saying you seem to be too accepting of that status quo. You need better capacitation.
Well, yeah, in fact, it's something that I raised when I was appointed in an acting capacity. That was 2022. I said, well, I suggested that Section 18 of the Electoral Commission Act should be amended so as to increase the number of judges. And then subsequently, I said, well, I need a registrar and a researcher. And election do not occur every day. So during the off-season, we can share the registrar and a researcher with the High Court, with the SCA, because we're sharing the facilities, we're sharing the resources. So the point I was trying to make is that, yeah, we can kill two birds with one stone. If they give me additional capacity, that capacity will also serve, because of the location of the court, that capacity will those resources can be deployed for the SCA. So that is what I suggested just before I was appointed, and I'm still raising it now.
Well, you didn't raise it. I wanted you to raise it because I think we are too accepting of the responsibility to deliver.
Yeah.
Yet we don't have the right capacitation around us. I mean, your secretary doubles up as a registrar of the electoral court. Am I correct?
Yeah. Well, that's. If you look at the heads, the letterheads of the electoral court is the registrar of the SCA.
I understand that, but I'm just, well, I think we've made that point, that the SCA is limping in terms of research capacity. It's also limping in terms of registrar capacity. I know that for a fact. And now we're overburdening an individual and to try and keep to the expectations of delivering as expected. I expect you as my superior to have your voice louder in this field. Thank you, CJ.
I think the JP is saying, Justice Zondi, fight. Don't accept this. And if you want to know who to fight, I'm not saying anything. I'm just stretching my hands.
But, well, just off the record, CJ, you recall that when we had the meeting with them at the OCJ offices, the specialist court, I raised that issue, and that was before I was appointed as on a permanent basis. I said, well,
no, you are right.
That was following the decision of the Concord in the New Movement case. I said, I foresee a problem here.
Yeah.
We are going to have a lot of work here. But this court, the number of judges that this court has, that court is not going to be able to function effectively. We need to amend the legislation and we need to increase the number of judges so that we can run this court efficiently.
Well, Justice Zondi, I agree. You were in that meeting,
Yes.
which I had called specially, and the minister was there because I wanted us to address these issues. But you see, that is what heads of court have to keep on doing. They are always fighting for resources, and that fight is not going to end until the executives agrees to this judiciary having full institutional independence. That's why members of parliament must help us fight this fight, because the executive doesn't want to let go. If we control the resources ourselves, you would long have got a registrar for the electoral court and other resources. But I think the JP was saying, fight. Okay. I think the last one is Commissioner Jojo.
Thank you very much, Chief Justice Zondo. Good afternoon, Justice Zondi.
Good afternoon,
It
Commissioner.
flows well, Zondo, Zondi. Yeah, thank you very much. I'm worried and I want you to allay my fears.
Yes.
The position where you are nominated it is the fourth in terms of seniority in this country. Chief Justice, Deputy Chief Justice, President of the SCA, and Deputy President of SCA is very, very senior. And it is at the second highest court in the land, just after the Concord. Now, my worry is one. And I follow up what Minister Lamola was traversing with you. As a chair of the Electoral Court, this judgment that was overturned yesterday received a lot of attraction and criticism. And I'm worried because at the center of this is what is entrenched in our constitution, namely the right to vote and the right to be represented in parliament, and in this case, the National Assembly. And with this judgment that you were involved in, that found out that Mr. Zuma was not disqualified as his prison sentence was not issued by the Concord, it is worrisome to me. And I want you to allay my fears that for the implication of the future perspective, if you are considered for this, such terrible mistakes must really be avoided, because elections have got profound implications for the country. One mistake can cause civil war in this country. It can cause our country to deteriorate, because at the center of who we are and what we are is the right to vote and to have representatives at the level of parliament. And this, for me, I don't really understand. And I want you sitting here to allay my fear that looking at this judgment and what happened and what unfolded, such mistakes will try our level best. I'm not saying that to as human, I'm not saying that mistakes can happen, but such mistakes will try our level best to avoid them. And I want you to address me on that and allay my fear that I mustn't be worried. I must be certain that at that level, as a deputy president of the SCA, such mistakes will not arise. What is your comment on that?
Thank you, Commissioner Tudu. Well, take it from me that mistake, well, do occur, but I think that what is important is the reasoning that you use to arrive at the outcome. The reasoning, well, I had thought that the reasoning that I used was the correct reasoning to reach the outcome that we reached. It's unlike a situation where the conclusion that you reach is not based on the sound reasoning. That was the question of interpretation of the statute, as I've indicated, that it's sometimes you might make a mistake in interpreting a statute, as long as if the reasoning that you use show that that person has applied his mind to what he was doing. I think that the mistake can be tolerated, and it's something that I don't think that will happen again. And but that was a novel case. That is a novel kind of situation where you had, but at the same time, it helped us that the matter went to them. I'm glad that it went to the Concord, because it tells us one thing, that what does it mean for the Concord to exercise power on the matter that is before it on direct application. In other words, if there is a direct appeal to the Concord, it doesn't go via to the SCA. That in some instances, it will happen that the Concord will be the first court of instance and the last court of and the last court. In those circumstances, then the judgment of the Concord will be final. It taught us a lesson here that sometimes you can't just read the words as they appear in the statute using their ordinary grammatical meaning. You have to read the words purposely and within the context of.
May I ask you to wrap up, Justice Zondi?
Sorry?
To wrap up on your answer.
Okay, sorry.
And also,
yeah.
can I just follow up? I know Commissioner Todovo. What he wants is, yes, it was an error. It was a case.
Yeah, no. That's why I've been waiting. I've been hoping that it's going to stop. Okay.
Commissioner, I'm not going to accept.
It's fine. It's fine. It doesn't serve any purpose for our purposes.
Yeah.
Okay.
I'm trying my best to be compatible with your legal jargon. It's difficult under the circumstances, but thank
I'm
you
sure
very
you are
much.
leaving it there.
No, it's okay.
Commissioner.
It's okay.
Yeah.
Okay.
Okay. All right. Well, that was the last one, but that was the last one because I've got no other hands. But I want to clear something because we are in the public domain. Commissioner Todovo, you were a part of the parliament that amended the constitution in 2013. And I assume.
In respect of which matter?
I'll tell you just now.
Okay. No, not 13.
In terms of which you took the constitutional court from where it was up to that point, which was considered to be on the same level as the Supreme Court of Appeal. You lifted it up to be the apex court. When you lifted it up, you didn't lift just the structure. You lifted the judges as well to be up there. So whereas prior to that, it may have been true, your understanding of the structure. The justices of the Constitutional Court, on my understanding now, since then, are in the highest court in the land, above all other courts. Okay? In terms of seniority, you remember what you said to him. You said if he's appointed, he's going to be number 4. You see?
That's a mistake on my part.
Yeah, you
I see.
see, you
I
lifted the
concede,
Constitutional
yes.
Court up to the highest, to be the highest. It went up with all its judges.
Yes, I see.
Okay, all
I
right.
learn. That means the 11 of you are ahead of any other,
Yeah.
including
Yeah.
the SCA,
Yes.
including the
Let's ask the
president.
president of the SCA.
Let's not say anything.
No, Chief Justice, I would like the view of the president of the SCA on this matter.
I'm going to protect it. I'm going to protect it.
I have no comment.
Thank you very much, Justice Zondi.
Thank you.
We have reached the end of this interview. Once again, I thank you for coming to this interview, availing yourself, and I am happy to tell you that you are the last candidate I have interviewed in this body.
Okay.
Thank you very much. You are excused.
All right. Thank you. Thank you very much, commissioners. Thank you a lot, CJ. Thanks a lot, Minister. Thanks a lot, President.
Thank you.
CJ.
Goodbye.
Thank you.
Yeah, thank you, CJ. I just want, on behalf of all the commissioners, to also thank you for the service that you have provided to the commission It has been collegial. We have worked very well with disagreements, but very robust, and we're taking the country forward. So we wish you well in your endeavors. Thank you very much.
Thank you very much. Thank you very much. Thank you very much. I must just also say, I really have enjoyed working with all of you. It's been wonderful. It's been very collegial. I've received a lot of support from the time I came in, and I will miss coming back to this board. So, but thank you very much to all of you, each and every one of you. You have been very supportive. Thank you.